Hi everyone, let's talk about agency formation and termination. In this lesson, we'll define agency and identify the parties to a principal-agent relationship. We'll describe a principal-independent contractor relationship. We'll describe how express and implied agencies are created. We'll define a parent agency. We'll list and describe the duties of a principal and those of an agent. And we'll describe how an agency is terminated. So, even though you might not be aware of it, these agency relationships exist all around us. So it's very important to understand them. So that's why we mention it here. But the law of agency allows one person to act on behalf of another person. So I'm authorizing a person to make decisions or do business on my behalf. Agency law is a large body of common law that governs agency. It all evolved. You could trace it back as far as you want to go. We can trace it back to British common law. They can trace it back to Roman law, Greek law. However far you want to go back in time, you can find the roots of where this all comes from. Okay. So a little bit of terminology. The principal is the party who employs another person to act on his or her behalf. And then the agent is the party who is acting on behalf of the principal. A little graph to sort of illustrate it for you. So a principal and an agent form a relationship. We'll call this the agency contract. The agent is then authorized to do business on behalf of the principal. So the agent can go out and form a contract with a third party on behalf of the principal. The principal is now bound to this contract and must perform their obligations that are stated in that contract. Who can initiate an agency relationship? Well, pretty much anybody who has contractual capacity. They can appoint an agent to act on his or her behalf. Sometimes we run across people who lack this capacity. If you remember from Business 115, you can lack capacity for a few different reasons. One, if you're not 18 yet. Two, if you're declared legally insane. Three, if you're extremely intoxicated in some way. But these are the things that can serve to take away a person's capacity to contract. If you lack that capacity, and in some situations, a court could potentially appoint an agent for you. An example of this is a conservatorship relationship. The most relevant one to our timeline now was there was a couple documentaries on Britney Spears' relationship with her father. She was declared to lack contractual capacity and was placed into conservatorship, where her father was appointed as her agent to make all the decisions for her. She recently got a court to remove that conservatorship and allow her to make her own decisions. So I guess we'll see what happened. But this can also happen with older people who are just declared mentally incompetent to manage their own affairs anymore. So, it can happen. The principal-agent relationship is when a principal hires an agent and gives that agent authority to act and enter into contracts on behalf of the employer. In this example, the employer is the principal. We contrast that with a more simple employer-employee relationship, where an employer hires an employee, but they aren't given authority to enter contracts. For contractual purposes, the employee does not have authority to form those contracts. However, having said that, the employer still does have vicarious liability for any torts that are committed by employees who are acting within the scope of their employment. We'll learn more about this in later chapters, but this concept of vicarious liability is extremely important when you're hiring people, because you have to be aware that you will be, or you can be, held liable for the conduct of those employees if they're acting within the scope of their employment. More on that in future chapters. An independent contractor is someone who is not an employee of the principal. They usually own their own business, and they've been employed by the principal to perform some specific task on behalf of the principal. So the principal can authorize a contractor to enter into contracts, and then the principal would be bound to those. But the contractor is not an employee. This differentiation between employee and independent contractor, again, extremely important in the business world. You'll learn more about that when you take employment law, and then we'll discuss some of it in this class as well. But the liability that a principal has to a contractor versus an employee is very different. Anyway, some examples. Maybe if I hire an architect to design a house for me, if I have a stock broker that I authorize to make trades on my behalf, a real estate broker that I authorize to make real estate deals, an electrician that I hire to come and fix something for me, same for a plumber, same for an accountant, same for consultants. Now, all these people could potentially be employees as well if I have that relationship. It's just very common in these professions for them to be hired as independent contractors in an agency relationship with the principal. So how do we form an agency relationship? We have 4 ways. We have express agency, implied agency, agency by ratification, and apparent agency, and we'll discuss each of those in a little bit more detail here. So an express agency is when a principal and an agent expressly agree to enter into an agency relationship with one another. This can be oral or it can be written. It only has to be written if the statute of frauds stipulates that that particular type of relationship has to be written. And there also exists what we call an exclusive agency contract, where once we form that, then the principal can't hire any other agent. Several years ago, when I was looking to buy my very first house, I hired a real estate agent. And at that time, it was very common for real estate agents to make you sign agency contracts with them. And oftentimes they would be exclusive agreements saying that for some period of time, call it a year, call it 2 years, I wouldn't hire any other real estate agent other than this one that I had formed a contract with. And if they found out that I did, then they could come after me for agency fees if they found out that I bought a house using another real estate agent. I don't think that's really that common right now, but you can expand that concept out to any type of principal-agent relationship there. Power of attorney is one of the most common express agency agreements. It's when I give somebody the authority to sign legal documents on my behalf. I give the agent authority to form and sign legal documents on behalf of the principal. In a general power of attorney, again, just some terminology here, broad concepts. General power of attorney, I give them broad powers for all sorts of transactions on my behalf. In a special power of attorney, we're going to limit that power to specific matters. For instance, just a real estate deal, or to make medical decisions, or insert anything else that limits the power of attorney. And then finally, a durable power of attorney is one that continues even if the principal is incapacitated. So the general rule is that a power of attorney would no longer be in effect if we found out the principal is incapacitated, if they're, unconscious in the hospital in a coma or something like that, or if they're declared legally insane, things like that. But a durable power of attorney survives that incapacitation. So if you ever, when my wife and I were having our first kid, we went and created a will and powers of attorney. And sorry, my power flickered for just a second. I was hoping the video continued. I think we're good here. Anyway, we're signing these documents, and we signed durable powers of attorney. So we specified people in our lives that we would give authority to sign legal documents on our behalf, and specifically to make medical decisions on our behalf if my wife and I were, for some reason, involved in a car wreck and we're in the hospital, unable to make our own decisions. The durable power of attorney would allow somebody to make those decisions for us. Okay, an implied agency. This is an agency that occurs when a principal and agent do not expressly create a relationship, but it is inferred from the conduct of the parties. Okay, so the extent of the agent's authority is determined from the facts and circumstances. We usually find out about these implied agencies. They're usually determined by a court if we're actually in a trial. But the basic idea being that, so I'll give you an example. So the example is, let's say I'm a manager of a retail store. I notice a water leak. If this leak continues, it's going to cause extensive damage. That's going to cost a whole lot of money. I try to call the store owner. I can't reach him. So I just call a plumber to come fix the leak. Later on, the plumber tries to go collect money from the store owner, but the store owner doesn't want to pay, saying that they didn't hire the plumber. If it goes to trial, the court's probably going to decide that there was implied agency there. Even though my contract with the store owner doesn't expressly give me the authority to hire a plumber on the owner's behalf, the court will probably determine that implied in the relationship is the fact that I should be looking out for the best interest of the store and the store owner. So they're probably going to force the store owner to just pay the plumber. The owner should be happy that I did that, but I don't know. People are crazy sometimes. Agency by ratification. Another way that agency relationship can occur. This is pretty rare, but let's say a person misrepresents themselves as being an agent when they actually are not. But then later, the principal actually accepts the contract that was created or the act that was done, and therefore the principal would then be bound to it. And then the agent would also be relieved of liability for misrepresentation. So this can happen sometimes. You know, if I hire an employee to work at my store, and somebody comes in trying to sell something to the store, and they're probably looking for me to try to sell it to me, some new product they want to put on the shelves. Now, I didn't give my employee authority to actually make those kind of deals, but they think that's just a blowout deal, and I would be crazy not to do it. So they say that they're my agent, and they have the authority to do this, and they form a contract to buy this product and put it on my shelves. So I find out about it, and if I don't like the deal, then I can hold my employee liable for doing this bad deal. But if I like the deal, if I think they were actually right and I would be a fool to undo this deal, I can actually ratify it. The agent would no longer have any liability for misrepresentation. I would then be bound to the contract. So here we have a case that happened right here in the great state of North Carolina, Matthews versus Food Lion LLC. So we have an employee who finishes her shift. She clocks out and is getting ready to go home, but she decides she needs to go to the bathroom first. So she is in a hurry. She rushes back to the bathroom. She throws the door open, and she didn't know that there was another employee right behind the door. The door crashes into the other employee. She falls down. She suffers some medical injuries and has to go to the hospital. Okay, so the person who was injured, the plaintiff here, is suing both the employee and Food Lion to try to recover damages for her injuries. You're usually going to try to go after the business because it's more likely that the business has the kind of money to pay out a large judgment, as opposed to somebody who's just being paid a cashier's salary at a grocery store. So the question arises, was Hall is the employee who hit the other employee. Was Hall acting within the scope of her employment at the time of the accident? So we have a genuine question here as to whether or not Food Lion is going to be liable. Food Lion, of course, is going to try to deny this liability. And then the plaintiff is going to try to claim that Food Lion does have liability. What the court found was that since the employee had already clocked out and was no longer acting within the scope of her employment, was not performing any job functions, that Food Lion was indeed not liable for injuries as a result of this accident. I could have maybe called that one a toss-up. It would depend on sort of the viewpoint of the judges there. But yeah, that was the decision. Not acting within the scope of her employment, therefore Food Lion not liable. This case happened in Massachusetts. Is kind of a strange case where we have some dine and dashers, some teenagers eating at a Chili's, and they ran out on the bill. Now, there was a patron, not an employee, just somebody else that was eating there at Chili's, saw what happened. He got in his car and decided he was going to follow the teenagers, try to chase them down, try to get their information, try to get these kids in trouble. So what resulted was then a high-speed chase, and then the teenagers crashed their car and suffered injuries. The teenagers sue, or the parents of the teenagers sue, to try to recover damages. They sue both the patron who followed them as well as Chili's, again, hoping that Chili's probably has more money than just some guy eating at a restaurant. Then the question arises, is Chili's liable here? Was the patron eating in the restaurant an agent of Chili's? And the court decided that no, there didn't seem to be anything that would indicate any type of agency formation in this whole situation. You just had a guy who tried to be a hero and ended up in a very unfortunate situation that he would be liable for, but that Chili's would not be. Next, we look at apparent agency, which is also known as agency by estoppel. This is when a principal creates the appearance of an agency that actually doesn't exist. If the apparent agency is established, the principal is estopped. That translates into just being stopped. Sometimes we deal with antiquated language in the legal world. That's just because so much of this language can be traced back so far in time that language has just changed from now to then. But anyway, if this happens, the principal is stopped from denying the agency relationship and is bound to the contracts that are made by the apparent agent on the behalf of the principal. And it's important to note that in this particular type of formation, it's the principal's actions and not the agents that create the apparent agency. For an example, let's look at a case study. In this example, we have a defendant who is complaining of pain. They go to get a colonoscopy in which a mass is found. They're then later sent for a CT scan to try to learn more. The hospital, then we have sort of a chain of other people hiring other people, where a hospital hires a company, the company hires another company, that company hires a radiologist to actually do the scan. Okay, so they do the CT scan, and even though the mass showed up on the CT scan, the doctor missed it and failed to report it accurately. The cancer later developed, metastasized, and then greatly reduced the defendant's prospects for survival, so they sued for medical malpractice. So the question is, was Dr. Walker an apparent agent of the defendant? What the hospital is trying to say is that they're not liable because Walker was not their agent. He was an independent contractor who had been hired by a different business, and thus how could the hospital be liable for what this other doctor did who wasn't their agent? And during the court proceedings, what the court found was that the defendant, the injured party, had no notice or no way of knowing whether or not this doctor was actually an agent of the hospital. They just assumed that as they're being sent to these places, that the people that are providing medical care are employed by the hospital system and thus are their agents. So why should they be able to escape liability? And that's what the court found. So that kind of opens up to different questions. For instance, what if in the paperwork they're signing, the defendant was notified that the doctor was an independent contractor and was not actually employed by the hospital system, would that have changed the situation? The answer is unclear, but probably so. It probably would have changed things a little bit. Maybe they would be able to sue the doctor, but not the hospital system. Okay, so what duties do principals and agents have to one another? We'll start off with the principal and look at the main duties that a principal has. First one being to compensate. So they have an agreement, and so when the agent performs, then they should be paid. Usually the contract is going to specify whatever the compensation is going to be. However, if the agreement does not specify the amount of compensation, we have a couple of options. One is that the principal will pay the agent the customary fee paid in the industry. For example, we take real estate contracts are the ones that are the easiest for everybody to understand because most people have dealt with this kind. So let's take a real estate agent. Customary in that world that the seller pays an agent 3%, both for the seller's agent and for the buyer's agent. So then they pay a total of 6% of the purchase price of the house. And that's for just, general people buying houses to live in, these kind of residency contracts. However, if there's no customary fee, then what would be paid is, and this would be determined by a court, whatever the reasonable value of the agent's services would be. So then they have to look at the circumstances, what is reasonable to pay this particular type of person in this particular set of circumstances, and then they arrive at some dollar amount. There are also relationships where the agent is working on contingency. So the agent only gets paid if the agency is completed or if some certain benchmark is met. So this would be the case if, in a real estate contract, the agent only gets paid if the house sells. I can also, if I've been injured and I hire an attorney and I hire them on contingency, they only get paid. I only pay the attorney if I win the lawsuit. And if we lose, the agent or the lawyer doesn't get paid. And if the house doesn't sell, the real estate agent doesn't get paid. So that's what contingency fee means. I also, as a principal, I have the duty to reimburse. So oftentimes agents will incur expenses and then pay out of their own funds while they're performing some type of duty for me. And I have a duty to reimburse them for those expenses as long as, and we set out some stipulations here, as long as the expenses were authorized by the principal, if it's within the scope of the agency, and it's necessary to discharge the agent's duties in carrying out the agencies. And then we say, a lot of times we say, unless otherwise agreed upon, because in the contract, we can set out situations that may say that there is no duty to reimburse, and the agents, if they pay anything, they're paying out of pocket. We can agree otherwise in a contract, but unless, if we don't state otherwise, then this duty to reimburse exists. So if an agent is traveling and they incur travel expenses, if they have to stay in a hotel, if they have to buy flights, things like that, they would need to be reimbursed. Principal also has a duty to indemnify. This means that if an agent is held liable for some type of action of the principal, then the principal would have to reimburse the agent. What does that mean? All right. So let's say an agent goes out and forms a contract, but then the principal, who is bound to that contract, breaches the contract. The third party with whom we have the contract, they sue, and let's say they sue the agent for some reason, and then a court finds in the third party's favor. The agent could then go and tell the court that the principal has a duty to indemnify them for that judgment. So the principal would be the one that's on the hook for actually paying for the breach rather than the agent. That's all that means. It gets a little confusing, but that's what it means. Finally, we have a duty to cooperate. So the plaintiff, or not the plaintiff, the principal has a duty to cooperate with and assist the agent in the performance of the agent's duties and in the accomplishment of the agency. Again, example of a real estate deal. I hire an agent. I want them to sell my house for me. One of the duties that I have as the principal is to cooperate with them. So they call me and say, hey, I've got 3 people. They want to look at the house. So can you get out of the house so that I can show it tomorrow between the hours of noon and 5 o'clock or something like that? As long as they're asking during reasonable times, then I have the duty to at least cooperate with them and try to find times where they can show my house. If I just refuse to show it at all, then it's not really reasonable for me to expect the agent to be able to perform their duties. Okay, switching gears a little bit. What duties does the agent have in this relationship? Okay, well, they have the duty to perform, which means performing the lawful duties expressed in the contract and meeting the standards of reasonable care, skill, and diligence implicit in all contracts. This is a pretty flexible stipulation here because agents can be all sorts of different people, plumbers, electricians, lawyers, whatever. And so we apply a reasonableness standard here, saying, well, given this profession, what would we expect a reasonable attorney to do in this specific set of circumstances? What would we expect a reasonable plumber to do in this specific set of circumstances? So, this is the kind of thing that a court would determine later on if it actually goes to a trial. But basically, the agent has a duty to do what they said they were going to do in a reasonable manner. They also have the duty to notify if they learn information in the course of their performance that the principal really should know. They have a duty to tell the principal that information. Imputed knowledge, we're getting a vocabulary term here, is information that is learned by an agent that is attributed to the principal. So if during the course of real estate example, again, I hire an agent to try to sell a house. As the agent is talking to, actually, let's flip the relationship. I hire an agent to help me buy a house. So I send an agent out there to go and try to find houses within my price range, within certain parameters that I set for them. They go and they find a great house. It's for sale. They're talking to the owner, and the owner tells them that, yeah, the last owner was actually murdered in this house. Okay, so the real estate agent now knows this. Now, in North Carolina, you aren't necessarily forced to disclose that information, but if somebody asks, you have to tell them. So if the agent finds out about this, they should tell me, the buyer, the principal, about the knowledge they learned. If they don't, and then I buy the house, and then I later find out about this, and I think that this type of information is the kind of thing that would greatly reduce the value of that home, then I could go back and try to recover damages from my agent because they should have notified me. And it doesn't have to be something like a murder. It could be something like foundation problems, something that they learned about that would affect the value of the home that they didn't tell me about. Imputed knowledge, circling back here. When an agent learns out about something, it's assumed that the principal also knows about that, whether or not the agent actually told them. So you could think of situations where the principal is on the hook for something and you think they have certain information when they really don't. And that's where we have a conflict. That's where we have a problem. And that's where an agent could really be in trouble there. An agent also has a duty to account. Call that the duty of accountability. They are to maintain accurate accounting of all transactions that are undertaken on the principal's behalf. So if my attorney comes to me and says, here's your legal bill, I can say, well, I need a detailed accounting of all these expenses just to make sure that you're not just, pumping up the numbers just to try to make more money. So So at any point, I, the principal, can demand an accounting from the agent. So this requires that the agent has to maintain a separate account for the principal so that we can have this accurate accounting. And we also have to use the principal's property in an authorized manner. Okay, so not acting outside of the scope of my authority. So when we want to terminate an agency relationship, there's a few different ways. The first one here being termination by an act of the parties. So the parties to an agency contract terminate the contract by mutual agreement, or when a previously agreed upon event occurs. So some examples here. We have mutual assent of the parties. Both parties agree to terminate the relationship, even though the relationship was to continue for longer. We both just agreed to call it quits right here. If in the contract we state that the contract is only good for a specific amount of time, like 3 months, 6 months, a year, whatever, that time lapses, then the agency is terminated. If a specific purpose is achieved, for example, buying a house, we close the deal, then the agency relationship is terminated. Or in a legal relationship, if I hire an attorney and then we win the case, agency relationship is terminated. Or the occurrence of a stated event. I hire somebody to house sit for me for as long as I'm gone. And then once I come back and I want to live in my own home again, then that relationship is terminated. Speaking of termination, the principal oftentimes is going to need to give notice of termination. This is because if I terminate an agency relationship, but the third parties that I'm dealing with don't know about the termination, then the agent could go out and keep creating contracts, misrepresenting themselves as being an agent of me. But if the third party doesn't know about that, there's a chance I could potentially be held liable for that. So I'm going to give direct notice to all the people that I'm dealing with, all the people that the agent has been dealing with. Hey, this person is no longer employed by us. They no longer have authority to create contracts on our behalf. And then constructive notice, if you think that there might be people out there who the agent hasn't directly dealt with, but we're just going to give constructive notice to the entire community just so everybody knows that this relationship is terminated. You could run the ad for instance, you can run an ad in a newspaper in a geographic area, and then that would constructively give notice. If it came up in court later on, I could say, well, I ran this ad to notify people. And then the court will probably agree with me there. We can also terminate an agency relationship by an unusual change in circumstances. So something happened somewhere along the way that changes the circumstances so much that the original agency relationship doesn't really seem to make sense anymore. Then we could terminate that agency. We could also terminate by impossibility of performance. So things that can lead to impossibility of performance, let's say the subject matter of the agency is destroyed. So if I'm hiring somebody to sell a house, but the house burns to the ground, then it doesn't really make sense anymore for me to try to sell the house. So the relationship is terminated. If we have the loss of a required qualification. So if I hire an attorney to represent me in a lawsuit and I find out that they're disbarred and lose their license to perform law in that state, then the relationship is terminated. We could also have this due to a change in the law. So if I have, a contract to sell, let's see, what would I want to sell? I want to sell chewing gum, but then for some reason, the government decides to make it illegal to sell chewing gum. Well, then the agency relationship would be terminated. It would be preposterous for that to happen, but just as an example. We can also have termination by operation of law. So certain times when the law just says, well, agency relationships no longer apply here, and they would be automatically terminated by operation of law. So if the principal or agent, either one dies, then it's terminated. If either one is declared to be insane, it will be terminated. If the principal declares bankruptcy, it would be terminated. Or if we have an outbreak of war between the principal's country and the agent's country, then we can terminate that agency relationship. That can become an issue if we have these big international contracts. If the two parties declare war against each other, and then one of them tries to sue each other for breach of contract or something like that, then they would probably be allowed out of that. In these situations, by operation of law, there is no duty to notify third parties about the termination of that relationship. Finally, we have wrongful termination, which if one party tries to terminate an agency contract, but that violates the terms of the agency contract, one party could sue the other for wrongful termination and recover damages that they might suffer. That wraps it up for this chapter. Hope you guys have a great day. Reach out to me if you have any questions.